Thank you, Doctor.
Yes.
Wait, please, Lords, I'll be very brief, Lords, for 15-20 minutes. Lords, some issues have not been covered.
What are the points that you want?
Yes, Lords, straight away. Lords, I have made a brief written note, but before I come to the note, Lords, I have made a chart of all the prayers for your Lordships. And one or two areas which have not been addressed. If your Lordships have that chart, which has, Lord, the list of 4 writ petitions on this side and 2 writ petitions on that side, it is document 8.
Document A?
Yes, Lord. It's a chart.
Document 8, Lords, consolidated prayers.
Filed yesterday, Lord. Serial number 1 and 2 are writ petitions filed by my learned friends, Lord, challenging the notice issued by the Speaker.
First one.
Yes, Lord. The first 2, but that was the Lord's subject matter of 27th order. Now, my Lords, item number 3 is a writ petition challenging the action of the governor, calling for the trust vote. Lord, that has also been addressed, Lord, at length. That is item number 3. Now, my Lords, serial number 5 at page 5 is a writ petition by us challenging a decision of the Speaker on 3rd July 2022 after his election, changing the recognition of the whip from Sunil Prabhu to Mr. Gogavle. But this is a area which has not been addressed, which I will not briefly touch upon. Serial number 6, relates to the actions of the governor, Lords, in administering oath to Shinde, and also, my Lord, that whether your Lordship should decide the disqualification petitions here. And lastly, my Lord, serial number 7 challenges, my Lord, notices of disqualification issued to us. Now, my Lords, I will limit myself, my Lord, to the challenge of 3rd of July 2022. And this challenge, my Lord, is an independent challenge, irrespective of the view which your Lordships will ultimately take as far as disqualification is concerned or governors, my Lord's actions are concerned. Now, kindly have a look at the writ petition itself, my Lord. The writ petition starts.
What is the writ petition number?
Yes, my Lord. That writ petition is 479 of 2022. Yes. Starts at, my Lord, 470 PDF, Common Compilation 1. 406. 406, no? No, it's not 460.
Common compilation.
That's 406, my Lord, I'm sorry. 406. Starts at
406. Common compilation.
Starts at 412. This PDF. Yes.
406.
406.
And if I can just quickly, my Lord, point out my prayer there, which is, my Lord.
One week.
I'm sorry.
Trying to pull out that. Which common compilation did you say?
Common compilation.
3C.
Common Compilation 1.
Convenience compilation?
Serial number 4. Convenience compilation.
It is convenience compilation, not common compilation.
Right.
Of documents.
Yes, yes.
Yes. Lords, kindly see my prayer.
Page?
Page, my Lord. For PDF, page 408. 408. Lord, this is to quash and set aside the communication of 3rd of July 2022. And the grounds taken are not that the Speaker could not have acted on the request of the legislature party. The Speaker is obliged only to act on the directions of the political party as far as para 21B is concerned. The decision of the Speaker itself.
Would not have acted on the
Lordship did not take down any notes. It's there in my note.
on the advice of the legislature.
Yes, that's right. I'll just show the documents, Lord, and straight away come to the note. If your Lordships have the decision of the Speaker, which is of 3rd of July, my Lord, at PDF, my Lord, 382 of the same volume, of CC, I'm sorry, CC2,
Which one?
my lord, CC2, page 382 of the convenience volume.
Serial number 5.
Compilation.
The running page is 369, PDF page 382. Your lordships are aware, my lord, this decision is taken after the election of the speaker, my lord, on 3rd, on the late night of 3rd. So kindly see what he says, my lord.
Just 1 second, I'm just trying to track it down. Convenience compilation 2, right? Yeah. Page
Page 382, I'm sorry.
82.
With reference to your above mentioned letter, I have been ordered to inform you that you have been replaced from the post of legislature party by nominating the name of Ajay Chaudhary. In this regard, you have raised the objection by addressing the letter on 22nd June. In this regard, after deliberation on provision in the law, Honorable Speaker, Maharashtra Legislative Assembly has cancelled the approval granted to Ajay Chaudhary as the leader, Shiv Sena Legislature Party, and kindly see the next, my lord, and approves the recognize the nomination of Eknath Shinde as the leader, Shiv Sena Legislature Party. Similarly, the proposal to nominate Sunil Prabhu as the chief of Shiv Sena Legislature Party is to be cancelled and to recognize the nomination of Bharat Gogavle as chief whip of Shiv Sena Legislature Party has been approved and recorded in the registry. So, my lord, my argument is limited to the second part of the decision.
Cancellation.
As far as, my lords, the replacement of Sunil Prabhu by, my lords, Bharat Gogavle by the action of the speaker on the 3rd. And the only material, my lord, which was there before the speaker was that letter of 22nd of June of, my lord, Mr. Shinde, which your lordships have seen, my lord. PDF, my lord, page 67.
It was seen.
Lordships have seen that, which encloses that resolution, my lord, of 21st, appointing, my lord, Sunil Prabhu.
Can you give us a cross reference?
Yes, my lord. That is page 60. No, the earlier. The 67. The letter, my lord, of Mr. Shinde to the Honorable Deputy Speaker is at page 67. If your lordships just have a look at that.
Page 67 at the same compilation?
Yes, my lord. Kindly see, my lord, the heading. It is not by a political party. Shiv Sena Vidhi Mandal Paksh Karyalaya. Clear, my lord, that the letter was addressed by the Shiv Sena Legislature Party at best. And this, my lord, is based on the resolution which was passed in Devadatt. Which is, my lord, that resolution at page 49. 62. At, my lord's PDF page 62. Again, Shiv Sena Vidhi Mandal Paksh Karyalaya. Sorry, sir. 55. PDF page 55. Again, the heading is also Shiv Sena. Yes, my lord. PDF page 55. Shiv Sena Vidhi Mandal Paksh Karyalaya. Now, my lord, the defense to this, in the reply, there are only two defenses taken, which your lordship, my lord, have to consider. One is this is an issue which is covered by 212. Court should not get into it. And second, in any event, it is the legislature party which decides the whip. Straight away, my lord, if I can place the reply itself, there are only two issues, my lord, which have been raised in the reply. Kindly turn to, my lord's PDF page 475 of Convenience Volume 1, my lord. If your lordships have page 475,
Sorry, which convenience compilation, please?
One.
Convenience Volume 1. Lords, I have put all this in the note. Your Lordships may not be troubled, my Lords, to make the.
Why don't you take
note
us,
of the pages.
run through that note rather?
Yeah.
Yes, yes, Lord. I'll just point out the pages and
That
straight
will
away.
be,
Yes, sir.
while you read it, you can
I will.
indicate.
Yes, sir. Lords, if your Lordships have page 475 PDF, their reply, my Lords, to this writ petition. The second column, my Lords, on the top, this is the answer to 479. Writ petition is not maintainable in view of 212. And in any event, speaker has no discretion in the matter and has to notify the will of the majority of the legislature party. The Lordships have made a note, my Lord. Similar, my Lords, averments are made at PDF, my Lords, 492, paragraph 35, 34, 35, and 36. So, my Lord, these are the documents which I wanted to show. Now, straight away, my Lords, if your Lordships come to my note,
Your notice,
my Lords, that is A2, my Lords. A2, it's called additional WS.
Devadatt, your A1 is about the 7-judge issue, I think.
Yes, Lord, that's right.
Correct.
A2.
Lords, at PDF page 2, my Lord, the first point, that as far as the validity of this decision is concerned, it's only your Lordships, Lords, who can take a view on this. And if your Lordships kindly see paragraph 8 and 9, this issue on, my Lord, whether the whip is to be issued by the political party or legislature party, Lords, my senior colleagues have already made Lord submissions, I will not repeat it. Paragraph 8, my Lords, I have extracted 2B. And 9, my Lords, I have given the reference to, my Lord, Mr. Sibbal's submission, where not detail Erskine May, etc. Whether it's clear, my Lord, that whip has to be issued by the political party and not by, my Lords, the legislature party. Now, my Lords, coming to the defenses raised in the writ petition, if your Lordships have paragraph 12. Paragraph 12, my Lords, I have extracted 212. If your Lordship sees 212, I'm sorry. It's the paucity of time, my Lords, I'm trying to hurry up.
Yes.
Lords, paragraph 12, 212 I have extracted. The first, my Lords, criteria for 212 to kick in is that the validity of any proceedings in the legislature of a state shall not be called in question. So my submission is, my Lord, that the decision of the Speaker of 3rd of July 2022 is not a proceeding in the legislature of the state. And, my Lords, I am fortified, my Lord, by Mohammed Siddiqui's case, which I have extracted in the next paragraph, paragraph 34, my Lord. The above proposition makes it clear that the finality of the decision of the Speaker and the proceedings of the state legislature being important privilege of the state legislature, etc. The proceeding of the legislatures include everything said or done in the House in the transaction of parliamentary business. Now, my Lords, deciding a whip or giving recognition to a whip has nothing to do, my Lords, with parliamentary business. Therefore, the primary, my Lords, ingredient of 212 is not satisfied. Second, my Lord, is a more fundamental argument that this is not a mere, my Lord's, case of procedural irregularity, but a case of substantive illegality and unconstitutionality. Your Lordships, my Lord, have from time and again said that 212 will not, my Lords, help the Speaker's decision to be immune from judicial review if it suffers from substantive illegality or unconstitutionality, even if it is proceedings in the House. Lord, the latest judgment here extracts the Constitution Bench judgment in Raja Rampa, And if I can just place, my lord, paragraph 431 of Raja Rampal, which is extracted at page, my lord, 6, PDF 6. Conclusion, my lord, S, bottom of that page. The proceedings which may be tainted on account of substantive or gross illegality or unconstitutionality are not protected from judicial scrutiny. Then similarly, my lord, U, an ouster clause attaching finality to a determination does not oust the power of judicial review, but not on grounds of lack of jurisdiction or it being nullity for some such reason as gross illegality, irrationality, violation of constitutional mandates. Yes.
Yes.
Now, my lords, as far as, my lord, the decision is concerned, that this is not a procedural irregularity, but a substantive illegality or unconstitutionality is borne by a plain reading, my lords, of paragraph 2 of the 10th schedule. And, my lords, all the authorities and material which has already been relied upon, my lord, that references I have given. If your lordships have paragraph 9, my lord, I've given the references, page 70 to 96. Paragraph 9, page 4 of this note, and I will not, my lords, repeat it. Now, my lord, the second point. Third heading in my note. What is the meaning, my lords, of a political party? Your lordships asked, my lord, during the course of our submissions. What does it mean? Now, my lords, I have tried to explain, because ultimately decisions of a political party, which I will demonstrate, my lord, are ultimately decisions of the political party expressed through its leadership. And when, my lords, 2B talks about directions of the political party, it means decisions of the political party as are communicated, my lords, to the speaker. Now, my lords, kindly have paragraph 19 of my note. The 10th schedule of the Constitution prescribes a code of prohibited conduct for legislators within and outside the House. Any commission of the prohibited conduct by a legislature envisages penalty of disqualification. Now, my lord, there are two categories of prohibited conduct which your lordships have seen, my lord. And the footnote will show, my lord, I'm not going to repeat it, what is prohibited conduct for the purpose of para 21A. I've given the references also. Resignation need not be, my lords, explicit. It can be inferred. Giving a letter to the governor, my lords, going to the governor with the opposition parties constitute para 21A. All the references are there. Now, my lords, the substantive submission on the term political party, if your lordships have paragraph 21 now.
It's not a nebulous concept.
The term political party occurring in the 10th schedule is not a nebulous concept, but a term which has a definite connotation. The term political party referred to in the 10th schedule is an association stroke body of persons which has a definite leadership structure which is recognized by the Election Commission of India under section 29A of the RP Act. A political party is not synonymous with its legislators. A political party includes in its ambit the entire organizational structure which is spread at several levels, block level, taluka, district and state level, apart from the primary members holding those posts. Your lordships have seen, my lord, as far as Shiv Sena was concerned, organizational elections were held in 2018 and the leadership structure was communicated in January of 2018. The documents your lordships have seen, I'm not going to point it out again. But those documents unequivocally show, my lord, who's the leadership of the political party. That is page 1, my lord, of convenience compilation 2. Now, my lords, there is how this concept, my lord, of political party was included. What is the history? I will not trouble your lordships with that. If your lordships straight away have now 29A, which is extracted in para 28. why this is important is that political party, my lord, is not something which is anomalous. It is very clear who are the members, what is the leadership structure. So when the 10th schedule says directions of the political party, it means the directions of the political party as is expressed through the political leadership of that party. Paragraph 28, my lord, 29A is extracted. If your lordships have PDF page 12, subsection 4 of 29A clearly states that the application shall contain the details of the president, secretary, treasurer, and other office bearers. So the leadership structure what has to be intimated to the election commission. Now, my lords, detailed guidelines have been made in the Article 324 under Section 29A, and that also, my lord, is a part of this very written submission. If your lordships, my lord, just have PDF page 21, it requires, my lord, the following documents to be submitted, which includes office bearers. Your lordships may kindly make a note at page 22, and also, my lord, affidavits to be given by the president and secretary, which is, my lord, PDF page 34. So therefore, my lord, coming back to my note, my lord, paragraph 30. The fact that Shri Uddhav Thackeray is the president of the party, as per the constitution of the party, was intimated to the election commission from time to time. Thus, the terminus of quo for deciding a disqualification petition under the 10th schedule in regard to the prohibited conduct of a legislature has to be with reference to the state of affairs of that political party as it existed on the date of alleged action of disqualification. The term political party in the 10th schedule is referable to the political party as registered and recognized by the ECI under Section 29A. Now, my lords, the next section that the 10th schedule is intended to maintain the integrity of the political party, my lord, your lordships have been taken through it. I will not, my lords, trouble your lordships with that. If your lordships now have serial number 5, Roman 5, my lord. Lord, this submission here is
Hiatus.
no, Roman 5 at page 15. The correct constitutional conduct for legislators who claim that they represent the original political party is to first get their claim resolved before indulging into prohibited conduct under the 10th schedule. Now, my lords, the core question, my lord, which arises for consideration of your lordships in this case is that when there is an intra-party dispute, can, my lord, certain MLAs take the defense that, look here, I am the political party and I will indulge into prohibited conduct under the 10th schedule. And after indulging into prohibited conduct, toppling government, forming the government, file proceedings on 19th of July before the election commission for, my lords, validating that claim. And the defense taken is, look here, I am the political party. So your lordships, my lord, are called upon to decide what is the correct course of conduct in this situation. Para 36, my lord, it is respectfully submitted that in the event of a dispute within the political party, the correct constitutional conduct for legislators who claim that they represent the original political party is to first get their claim resolved before indulging into prohibited conduct under the 10th schedule. It is submitted that if a legislature or a group of legislators have a claim that they represent the original political party, then it is imperative that such a claim has to be resolved or adjudicated upon and decided in accordance with law. Brahmanand Reddy, my lords, was already cited. It is no defense in a disqualification petition to say that the defectors have a claim of constituting the original political party. Till such claims of MLAs that they represent the original political party attain fruition by a process known to law, such MLAs are governed by the code of conduct prescribed by the 10th schedule. Any other interpretation would make the working of the 10th schedule untenable. In the facts of the present case, Sri Eknath Shinde and his faction resorted to prohibited conduct of violating the whip, indulging into anti-party activities, instead of getting their claims adjudicated or resolved in the first instance, and then indulging into political activity. So now the question is whether you undertake political activity contrary to the 10th schedule, indulge into prohibited conduct, or first get your claim resolved. Any other interpretation would lead to 10th schedule being rendered unworkable. This can be demonstrated by a simple example. A legislative assembly has 40 members. Political party A, headed by Mr. X, has 5 MLAs. Party A forms a coalition government with Mr. X as the chief minister. Subsequently, 3 MLAs out of 5 claim that they are the real political party. The said 3 MLAs go to the governor along with the opposition parties to form the government. If the disqualification petitions are filed against those 3 MLAs, the petitions will have to be decided with reference to the state of affairs as it existed on the date of prohibited conduct. This is in line with Rana of relating back. Thus, the faction of 3 MLAs should first get their claim of being the real political party adjudicated and determined, and then take a political decision instead of putting the cart before the horse. This is the only interpretation which harmonizes the provisions of the 10th schedule and the symbols order. This interpretation will harmonize various competing interests and objects and ensure that the integrity of the political party is maintained, and at the same time giving individual MLAs or a group or a faction the opportunity to get the political leadership changed in a manner known to law. My lords, the next submission, my lord, that if the contention of my learned friends is accepted, that moment there is a dispute within a political party, there can't be a disqualification petition, will lead to a complete constitutional hiatus, my lord, as far as 10th schedule is concerned. That, my lord, in paragraph 40, it is respectfully submitted that there cannot be any hiatus in the working of the constitution. It is the contention of the respondent. If the contention of the respondent is accepted, that the 10th schedule proceedings are hinged on a future declaration of their status and or their claim of being the political party, then it would result in a situation where in every case of disqualification, a defense would be taken that the defectors represent the political party and therefore no action of disqualification can be taken. Taking the argument to its logical conclusion, it would only mean that till such claim of the defecting faction that they represent the political party is decided by a competent forum, the 10th schedule proceedings cannot be proceeded with. This would result in a constitutional hiatus. Not then I have cited Supreme Court of Canada, my lord, that on constitutional interpretation, and also, my lord, your lordship's judgment in the Advocates on Record Association. Then, my lords, serial number 7. Lords, I respectfully submit that ultimately, my lord, your lordships will have to lay down the batting order, as my lord Justice Narasimha put it. Lords, that is paragraph serial number 7. It is imperative for this honorable court to lay down a constitutional sequence in order to harmonize the 10th schedule 179C as well as para 15. As is evident from the facts of the present case, the respondent MLAs, instead of first resolving their claim in a manner known to law, have resorted to prohibited conduct. The proceedings before the Election Commission were initiated only on 19 July, that is much after the disqualification petitions were filed on 23rd June 2022. Then paragraph 44 is the Lord's submission. Thus, it is imperative that this honorable court lays down the constitutional sequence and the legal permissibility of 3 distinct constitutional stroke statutory procedures, namely 1, proceeding of disqualification under the 10th schedule, that is 1. Second is 179C, my lord, which has already been argued, and then, my lords, paragraph 15 of the symbols order. It is respectful submission of the petitioners that the 10th schedule proceedings necessarily have a constitutional precedence over 2 and 3 above. Second, my lords, para 15 proceedings, which are based on the majority test, cannot be undertaken and proceeded with without final adjudication of the 10th schedule. And third is the nabam rebia, my lords, argument. Then last two submissions, my lord, are on the symbols order. And my lords, I have submitted that the reason is, my lord, that decision to the defense.
That's not an issue which falls here.
Yes, my lord. One of the questions which was referred to your lordships, my lord, in the reference order relates to the power of the election commission. But the only defense which is taken, my lord.
It's a separate.
Yes, my lord. The reason is, my lord, the defense which is going to come, the lordships will probably hear, is that look here, we have now been adjudicated as the party. So therefore, the disqualification petition are anyway not maintainable because it is, my lords, given by a person who is not a political party. So, my lord, just two submissions on that. If your lordships have paragraph 47, my lord, I have submitted that as far as para 15 is concerned, it cannot be undertaken, my lord, without determination of the 10th schedule, which your lordships will examine other matter. And last, my lords, paragraph 49 and 50 is that the decision of the election commission, my lord, is a declaration of status, that who is the political party pursuant to a split which has arisen. That can only have a prospective, my lord's, effect. It can't relate back. Kindly have, my lords, paragraph 49. It is submitted that under paragraph 15 of the symbols order. Yes. It is submitted that a decision under paragraph 15 of the symbols order is a decision which can only have a prospective effect. Then, my lords, I have quoted paragraph 15 of the symbols order. It's a quasi-judicial, my lords, adjudication under the symbols order. That, my lord, adjudication of the dispute results in an order declaring, my lord, XYZ as representing the political party. And this submission is, my lord, that can only have a prospective effect. Now, my lords, kindly see the consequence. If it is held otherwise, that it relates back, it would have, my lord, in our respectful submission, complete, my lord, disastrous consequences as far as the 10th schedule is concerned. Because when the decision comes, for instance, in this case, it has come in February, my lord. Petition moved in on 19th of July. And today to say that in view of this decision now, in February 2023, all the actions of prohibited conduct get effaced, my lord, would be to destroy the complete intent, letter and spirit, my lord, of the 10th schedule. Lords, all the other submissions and judgments are there.
Thank you, Mr.
I'm grateful for a very patient waiting. Grateful.